Planning your final arrangements means making that plan for what's going to happen when you aren't able to do that for yourself when you're no longer here.
It's really important to make these final arrangements because otherwise the burden falls on your family.
Your family's going to be grieving about losing you, and you don't want to put the extra burden on them of trying to figure out where your investments are at.
And also, you get a say in what's going to happen with your property and your assets that you have versus the state determining that for you.
Putting your plans in place take a lot of different shapes and forms. First of all, you have to know what kind of a situation you're in. People come from marriages where there's children from different families that have come together to form a new family. There's situations where maybe there aren't any children. There's situations where maybe you don't have any heirs. And depending on the situation that you're in, you're going to have to make different plans that fit the appropriate course of action that needs to be taken for you.
The difference between a will and a trust is that a will goes into effect when the person passes away, and a trust goes into effect when it's created.
The trust is going to allow your assets to pass without having to get a lot of extra attorneys and things like that involved, where with a will, everything kind of stops, we regroup, we go out and we find out who the executor is, get all the papers filed, and then we kind of start over and take the process from there. For some folks, the trust is the way to go. For others, the will is the way to go. And again, those are very personal decisions that you need to talk about with your financial advisor to make sure you're making the right choices.
Typically speaking, once you start to develop assets or get married and have a family, this is the perfect time for you to make sure that you have those plans in place.
If you go to the attorney and you take the time to pay the money to have a trust drawn up, but you don't take that the step further and bring it into the credit union and have all of your assets renamed in the name of the trust, your trust is going to do you absolutely no good. Because if the assets aren't titled into the trust is not going to be effective.
One of the most misunderstood things also is a lot of people think that once they list a power of attorney that they have access to the accounts now and in the event that they pass away, and that's simply not the way it works. The power of attorney ceases upon death, and then at that point, an executor would take over as far as an estate.
Trustees on a trust are also different than executors. These are all separate entities, and you need to figure out which one of those tools are going to be the best for your personal situation and then work through that.
Dupaco offers a lot of different resources for our members. One of which is an organizational tool we have on our website that helps you get your documents into order.
Now, we're not going to give you legal advice. That has to come from your financial planner or from your attorney. But we can let you know how things are set up at Dupaco and at least help get you on the right path to somebody who can help guide you through those decisions.